We've had the pleasure to work with Bob on a number of, almost all these issues over the years, going back a long time. He digs in, he gets into the middle of these issues, he really tries to understand it. We don't always agree, but we respect his commitment to try to get to the bottom of what really makes sense. He is a co-chairman of the Bipartisan Congressional Internet Caucus, chairman of the House Republican High Technology Working Group, and co-chairman of the Congressional International Anti-Pirates Caucus. And Congressman Goodlatte has been with us before a number of times, and we are really grateful to be able to have him back again. Bob.
Man, I feel so far away from everybody. I ought to have a microphone and be able to do theater in the round there. But Ed, thanks for having me back. We don't disagree on much, you know. There's just one topic, and I'll touch on that. Last Congress, we made a conscious decision to attempt to bring technology into the discussion more at the subcommittee. And since I became chairman in January of last year, we held hearings on ICANN, net neutrality, cybersecurity, and we've dealt with patent reform. We hope to continue that trend of highlighting technology, whether it is issues that affect the technology community or how technology can solve problems better than legislation, which I'm always in favor of when we can do that. The subcommittee will also be hard at work conducting oversight. We'll be looking into the implementation of the America Invents Act, our patent bill, and we will be looking into the administration's policies and their effects on competition in the marketplace. And we'll continue to look at intellectual property issues, but we are not looking to revive SOPA. Funny thing about that, huh? In my opinion, this is a serious problem, and I think most people in this room agree with most people in a room full of intellectual property content community folks like I'm talking to elsewhere today, because this is World IP Day. But it's important that these two industries get each other, because you're so vital to each other. The great content that is created needs to be widely disseminated on your systems, and therefore we need to find ways to make sure that people who create it are rewarded for it, and crooks who steal it are stymied in that effort and punished for that. What we did when Henry Hyde was chairman of the Judiciary Committee, and we worked on the Digital Millennium Copyright Act, Henry brought people together in a room like this, and he stuck one member of Congress, me, in that room with 25 or 30 different organizations, representatives on both sides of that issue, and some that had a foot in both camps. And we worked at it for literally months to find some common ground on notice and takedown, safe harbors, and things like that that are the hallmark of that section of the DMCA. And as we observe that times have changed, and internet speeds have changed, and the sophistication of criminals have changed, and business models have changed, and technology have changed, we need to bring that group back together, be a whole new set of characters. Some of them will be alumni from that previous, but there are a lot of new players on the field since then, and we need to bring them together to solve that problem. Patent reform. We will be conducting oversight over the implementation of the America Invents Act, and we will also look at patent litigation abuses and whether it is fair for there to be different standards for injunctions in the federal courts and at the International Trade Commission. Cloud computing is an important issue that touches on many areas within the jurisdiction of many committees, including Judiciary, and we plan to hold a hearing on the policy issues surrounding cloud computing, and also to educate members about this technology and the challenges that cloud computing companies in America face in the global marketplace. This subcommittee is, for the first time to my knowledge, bringing together the Intellectual Property Subcommittee and the Antitrust Subcommittee, really probably the most important subcommittee in the entire Congress. And so we have antitrust and competition issues that often affect the tech industry in many different ways, and we'll continue to watch industry developments and hold hearings as needed regarding various mergers and transactions that take place. Cybersecurity is the issue of the day, and we need to enhance our nation's cybersecurity readiness. As I stand here and speak, I am aware of the fact that the government in general and the House of Representatives in particular taking up this legislation. They've been prodded and poked by hackers and folks who would like to take down our system as we move forward. So today we're voting on a bill that helps to address the lack of information between government agencies and the private sector, which is a good start. I believe the proper role of the federal government is to create incentives for companies to adopt protections for their networks and information. We need to encourage this while ensuring maximum flexibility with regard to how companies achieve these better levels of protection. The private sector is best equipped to develop solutions to ever-evolving cyber threats, and Congress needs to avoid imposing heavy-handed, static regulations from Washington, D.C. In addition, our criminal laws are in need of an update to further address these threats. I recently circulated a discussion draft of cybersecurity legislation that enhanced criminal laws against cyber threats. However, in light of the recent Ninth Circuit Court of Appeals decision regarding whether violations of terms of use agreements could form the basis of a prosecution by the Department of Justice, I decided that members, outside groups, and other stakeholders needed more time to digest that decision before moving forward with introducing a bill, especially under the compressed time schedule for Cyber Week, as we're calling this week. Last year, I held a hearing in the IP subcommittee on ICANN's GTLD rollout. I also sent a letter in December along with Howard Berman urging the Department of Commerce to use tools in its arsenal to encourage ICANN to delay the rollout of unlimited GTLDs, or at least to encourage ICANN to roll these GTLDs out in stages so that empirical evidence can be garnered about the defensive registrations and other problems with the rollout. While the department did weigh in and express some concerns to ICANN, we need to monitor this rollout closely. In addition, international stakeholders with concerns should weigh in with their own governments so that more voices are singing the same tune and so that ICANN hears from countries other than the U.S. on this issue. The recent problems with the application process for GTLDs raise more questions about ICANN's ability to effectively enforce its policies with regard to this massive rollout. And that leads into my next topic, and a great concern I have. Another reason for other countries to weigh in is to avoid the appearance that the U.S. has undue influence over ICANN. The absolute last thing we need is for the UN to gain more control over ICANN or to create some alternative body regulating the functioning of the internet. And I think that is my number one concern about what I view as an overreach by ICANN, and that is if they blow it, they're going to find countries around the world more than willing to take this oversight responsibility off of their hands, and then government regulation of the internet is going to be in full bloom. We also need to look at the Electronic Communications Privacy Act reforms to see whether it needs to be updated for the 21st century. While this may be an issue for the next Congress, it is one that I'm very interested in. Technology has changed, and we have been left with a strange patchwork of rules that are inconsistent and confusing. Regarding privacy generally, I've always been a believer in opt-out as the best policy. Consumers expect a seamless internet and technology experience, and as long as consumers are informed about privacy policies and given an opportunity to opt out, the free market should be allowed to determine how to decide how to structure privacy policies. And I do think that some types of information, including information about children as well as financial and medical records, deserve a higher degree of protection. Then the Judiciary Committee in general has a couple of other issues that I have been at the center of that are also important for the tech community. One is green card reform. Many of you know that while we have struggled with H-1Bs, and we're at a level right now that seems to be sustainable for getting someone out of college or bringing someone from another country who is not a United States citizen and getting them to work at your company, after 6 or 7 years that H-1B visa expires, and because of the long waiting lists for immigrant visas, sometimes a gap develops which causes the company to have to let the employee go, move them to a new office they might open in another country in order to keep that valuable employee's services and actually take jobs out of the United States. Or some other circumstance that's not desirable. So I have legislation to eliminate the visa lottery or visa diversity program. We give away 50,000 green cards every year, not based upon job skills that are needed in the United States, not based on family reunification, but based upon pure luck. Those visas are not available to citizens from the countries where you have the highest demand and where oftentimes tech companies are hiring, like India and China. So there are about a dozen countries that are excluded from that program. Those are the places where those additional visas should be made available, and that is legislation that I'm pursuing, and then some of those 50,000 green cards could be used to work down those backlogs on countries with the highest demand. And then finally, let me mention the Business Activity Simplification Act. This is an effort to provide a clear, bright line test for companies doing business on the internet for what constitutes a nexus with a state under which the state can require that they file corporate income taxes, business activity tax returns, and so on. As many of you know, some states are very dedicated to finding the most de minimis contact with their state as being a basis for sufficient nexus for them to require you to file corporate tax returns, business activity tax returns, and so on. There's a lot of wasted resources on both the business side and the state side that could be eliminated if we had a clear, bright line test that told businesses exactly when they will have sufficient contact with the state to trigger certain tax liabilities. Now, unlike the unlike the streamlined sales tax, which has more of a dividing line between at least some internet companies and some brick and mortar companies, the business activity tax legislation, or BATSA, has broad-based support from the entire business community, brick and mortar and online, because all of these companies are affected by states. The state of New Jersey, for example, says that if you drive more than 6 tractor trailers through their state in a given year, that's on the New Jersey Turnpike to get to New York and New England, you're a sufficient contact with that state to allow them to require you to file a corporate income tax return. So these kinds of things need to be clarified and made simpler. Ed, let me take a question or two if people have.
I've got
something
a
on their
dozen,
mind.
but I'll hold them and let some people raise their hand.
Yes, sir.
Andy McFarland, Austin, Texas, Data Foundry. Let me respectfully suggest you might go back and check your terms of service with your internet provider, because I don't think anybody allows you to opt out of having your data inspected. You have to cancel your service. I've tried with the 2 fierce competitors where I live, cable and DSL, and there is no opt-out option.
Well, there should be.
Well, I agree, and maybe opt in. How about if I get to make the choice? If I want to, get my free phone company hat or something in exchange for my privacy, but there's no opt-out in America here, sir.
There should be opt-out for people who want that, and I would prefer that to opt-in because of the fact of the matter that you would not have a seamless operation of the internet. If I go on to Amazon.com, and they know because the last time I was on there that I bought a biography, and when the screen comes up and says, "Welcome back, Mr. Goodlatte, we have a new biography about George Washington," if I'm offended by that, I should be able to opt out. But I don't think that they should have to ask me my permission ahead of time to tell me that they know that I like biographies and they have a new biography to suggest to me. It doesn't make the internet operate as seamlessly as it should. And when I go to my men's clothing store in Roanoke, Virginia, the guy does the same thing. He knows what kind of suits I like, and when he has a sale on one of them, he calls me up or sends me a postcard and says, "Hey, we've got a sale on Hart, Shafter, and Mark suits," or whatever the case might be. "Would you like to come down and buy one?" And I don't think he has to have my permission in advance to send me that postcard. And so I don't think the standard should be different online. And if it is different in terms of people not being able to opt out, sure, we ought to work on that. Yes, sir.
Representative, I'd like to follow up. Ron, you provide us again with questions, just kick us.
No, go ahead.
The difference between the situation we're Andy, between your local broadband duopoly, is you don't have a choice. I have a choice whether to use Amazon.
Right.
And decisions are saying you don't have it. So you don't even have a choice.
Well, we'll be working on this issue, and I certainly believe that people should have the right to protect their privacy, but I believe in opt-out as opposed to opt-in. That's the only difference of opinion you and I have.
I'm not trying to so much argue.
Sure.
Just saying there is a distinction between when you're choosing a website, have no choice in your broadband carrier. It's either Tweedledee, Tweedledum, and they both give you no choice that you suggested. We would like to.
Well, look, what we're talking about is not having a choice on their part, but having a choice on your
Consumer
part.
part.
So you can opt out. Right, good. I thought we agreed.
Representative, there's there are, I think we should also consider, and I hope you do, my name is Vernon Irvin, I work for a company, CEO of a company called Virtual Computing, and we actually have a free market solution for privacy and security online. And we think that these sort of solutions that are based on technology and innovation should be given serious consideration. I think regulation is important, but as a lot of things have happened in this industry, good innovation happens in the free market, and please give those full consideration.
I agree with that 100%, and that's why I support opt-out as opposed to opt-in, because I think that if you have a situation where the free market will determine that and the consumer is an able participant in the free market, they can choose to use your technology to protect their privacy, and we should afford them the opportunity to do that.
Just to clarify, we're on the same page. I just think that we've tried to make a distinction. When you're in the carrier world, you don't have the same choices of a vibrant, competitive marketplace. So opting out may well mean I don't have service. When you're on a website, you have lots of choices usually. So it's the lack of real competition at the carrier level.
We're not opting out from using the company. We're opting out from the company having the choice to say they're going to use your information for whatever purpose they want to use it for.
But at the moment, you don't have it, they don't have that obligation, and you don't have the ability to opt out.
Right. Well, we'll certainly include that in our deliberation on this issue. I just don't want the federal government to step in and tell every business that does business on the internet, and the carriers are certainly one category of people, but there are all of you and a whole lot more that are doing business on the internet as well. And if every time you have to make a decision about information you have and whether you can share something of use, of benefit to the consumer, you have to first go out and get their approval. You have not a seamless internet on which people can operate.
We certainly agree, Congressman. I think the tremendous nature of the internet is so many different kind of companies and different business models.
Right.
One set of rules for all is not going to work. So
Sure.
we are on the same page.
Yes, sir.
Congressman, Andrew Feinberg from the Hill. You said just now that you were concerned about, in response to these guys' questions about the packet inspection, you said that you were concerned about that. Several years ago, the House Energy and Commerce Committee held hearings on the packet inspection, and I think it was when Rick Boucher was the chairman of the telecom subcommittee, and I believe he and maybe a couple others introduced bills dealing with this practice. Are you saying that in your judiciary subcommittee that you'll be willing to hold hearings on DPAC inspection and or possibly use legislation?
I'm saying, no, what I'm saying is that as a part of the overall examination, the privacy issue of which the Judiciary Committee has a role, we will be looking at this, and we will be looking at it from the standpoint of all the different operators on the internet. Yes.
Congressman, an issue that might be, or I put it this way, should be on your agenda, perhaps not for this Congress, but next Congress, is a,
Right, I think that's what I said, too.
yeah,
Go ahead.
but it's an issue that's going to be, it involves the first sale doctrine of the copyright law. The Supreme Court just granted cert in the Kurtzing versus Wiley case, which has to do with, parallel imports. And I think that it's sort of a replay of the Costco versus Omega case from a couple of years ago that the Supreme Court couldn't decide because Justice Kagan had to recuse herself. So this is like the same issue. It's like a do-over. But I think regardless of how the court comes out, it's going to be an issue that's squarely going to be in front of your subcommittee. Again, this would be, because they just granted cert, the case won't be decided until the next term. But at that point, I have a feeling there's going to be a lot of people who are going to be unhappy one way or the other.
And,
Well, no, I'm just saying that
well, look, we watch that very closely. We probably will wait to see what the court decides before we determine whether there's any appropriate legislative response to it. But we definitely will have that in front of us, and at some point in time, I would expect that we would have some hearings or other discussion on the subject, but I think it's premature at this point.
I'll try to save you and make a comment for you. I'm right over here.
Oh, yeah, go
Hi,
ahead.
sorry. I didn't realize it was Cyber Week this week, which is great to hear. But I want to congratulate you on using cyber not as a noun like everybody else seems to do. Just call it cyber. You call it cybersecurity. So congratulations on understanding that at least. Thank you. You know, as the DoD budget is declining, as you know, pretty fast. One of the issues that I see is that cybersecurity, even on the COTS tools, they're doing a great job. You know, General Basler and folks are doing a great job on the network side. But that's not only the only part of cyber, as you know. There's RF pieces and other pieces of cyber that are really scary, you know, on the offensive and defensive side. And so my comment to you is that as we decrease the DoD budgets, be careful of, like, for instance, the Army right now is going through a massive decline of COTS tools that they bought. You know, they have 3,000, 4,000 licenses, and they're trying to get down to under 1,000. But cyber is not an aspect of the selection criteria in those tools, for instance. So as we try to save money, I don't know if we're being very careful on very important criteria like cyber. So just an awareness, and there's many more issues like that, you know, out there. And they're doing a great job on the networks. You know, there's with the amount of intrusions that we're seeing coming in every day. But the issue has lots of facets. And there's a lot of people out here on this table in this world that have experience in that. So hopefully you'll grab from us, you know, from our experiences.
Yeah, I'm not on the Appropriations Committee and don't get to set those priorities, but I will tell you that in every part of government, there's tremendous amount of waste, but there's also very necessary expenditures, and your point is well taken. I just have to tell you that with trillion-dollar deficits 4 years in a row now, we got to make the cuts. The question then becomes, will the committees of jurisdiction over the various sectors of our government exercise the necessary oversight to make sure that when they do appropriate, they appropriate the funds where they're going to do the most good.
I think you have to mandate the metric to make sure that cyber, for instance, as one topic, is not forgotten in that selection criteria.
Yeah, I agree with that.
I have not seen that, by the way, in the appropriations for things like that in the Army, even the Air Force, 24th Air Force, who've done the cyber work. I don't see that. So even the cyber world folks are not really using that criteria. So just as a suggestion for policymakers and stuff, it's you have the power to maybe influence a little bit.
Yeah, I agree with that.
Hi, Congressman. Last year you held a hearing and you discussed the application of competition laws to regulated sectors like telecom. I think this was in reference to the open internet rule debate at the FCC. And you talked a lot about the application of Trinco and Credit Suisse and those precedents and how it confuses whether competition law will be applicable to areas like telecom, broadband. Can you talk about that a little bit and tell us, is there any plan to hold another hearing on that issue? Is there any plan potentially in the next Congress to look at legislation to clarify that area of the law?
Well, I don't have legislation at this point in time, but we do believe that there is a lot of confusion in this area. The Trinco decision goes to the question of whether you can mix antitrust law in an area where there's already regulation and effectively have both. And quite frankly, the regulation may or may not effectively deal with some of the anti-competitive practices that take place. So an examination of our antitrust laws, which are go back 100 years, and how they work in a broader environment where there is so much more regulation today than there was in the past, I think is called for, and that might lead to legislation, but I wouldn't want to speculate on what it is at this point. Yes, ma'am.
Hi, I'm Michelle Quinn with Politico. I just wanted to clarify what you said about ICANN. Are your they've gone through something a little rough patch this month with technical glitches. You're not saying that you think that's made it more vulnerable, but just the whole decision-making process. Is that
Oh, yeah,
correct?
absolutely. I think the ICANN decision with regard to GTLDs is atrocious, and I think that it is something that many, many people from many sectors of the economy expressed a great deal of concern about, and I think they have been driven by some other kind of motivation, and they have undertaken more than they may be able to responsibly manage, and it worries me, because if they don't handle this properly, there are plenty of people around the world, not me, by the way, but plenty of people around the world who would love to see more direct governmental regulation of the internet and to push aside or more directly control an organization like ICANN. And that, I think, bears a very close examination by anybody who's worried about the future of regulation of the internet, because there are plenty of folks, not particularly in the United States, but elsewhere in the world, who would love to see the United Nations and other international governmental bodies take control of this incredible engine of freedom and economic growth.
Congressman, let me, and like I said, I really wish you could stay an hour more. A lot of great questions, and you're involved and have important views on so many key issues. Let me, one of the things that at the beginning of last Congress that Republican leadership in the House undertook was a regulatory review, a review of basically regulations and the way they can hamper the economy. One of the things that didn't really get on that agenda that I have kind of talked about since that really made sense is to look at the IP regimes of patent, copyright, trademark. They are, in fact, regulatory regimes over the way information is created, disseminated, et cetera. And that the kind of value that comes from a regulatory analysis, cost, redefined purposes, cost and benefits, would be something that I think, if it was undertaken with that perspective, could perhaps be a form in which a lot of us could maybe get out of our trench warfare opposition and say, okay, where do we agree? What is the purpose of each of these different IP regimes? What are the potential, how do you regulate well? I mean, it's really, I think we all agree, we want those systems, we want, if you will, that category of regulation. But like, whether it's environmental or anything else, we want smart regulations. We want regulations that don't have unintended consequences. And I don't really think anybody has really taken a look at the IP regimes as regulatory regimes over the innovation process, over transfer of information, over distribution of information. And if in the transportation world, we say, hey, the creation, the distribution, instead of we look at it as, in fact, a regulatory regime over transportation, well, we're talking about transportation of ideas, the creation of ideas. And between you and the Government Operations Committee, Darrell Issa, et cetera, I mean, it seemed like we've got a couple of really savvy folks who could maybe bring that perspective to the table. So I just wanted to put it out there, maybe follow up down the road, but see what your reaction to that would be.
Well, I mean, it's an interesting idea, and it's one that has gone on for 200 years. It's just that technology has speeded up the sharing and transfer of great new ideas, whether they're patents or copyrights or trademarks. But let me just say that I'm a believer in the free enterprise system. I do believe that patent, copyright, and trademark laws need to be fair in terms of how they allow the creator of those brilliant ideas to exploit them. But at the end of the day, I think most of that comes from changing business models, changing technology, and quite frankly, the brilliant minds who say, okay, I'm gonna make a deal here to help protect somebody else's intellectual property right, and in exchange for that, I'm going to be rewarded in this other way. That would be, in my opinion, the primary way that the problem of SOPA is going to be resolved. Not by legislation. There are going to be legislative tools that are always needed, but I'm a strong believer in the free enterprise system, but I'm also a strong believer in that other part of our Constitution that recognizes the right of people to own private property, including intellectual private property, and I think it's very important that we protect that right. Now, the Constitution says for limited periods of time, and we've gone a long way, and I don't anticipate we'll make it longer. And some may make an argument that because of the rapid transformation of technology and the way people use it, some people might make an argument for a reexamination of those rules. But in terms of some kind of cost-benefit analysis that you seem to be suggesting, we would welcome the input. I'm not sure if I'd want to have a government agency doing the study. I think maybe some private foundation ought to undertake that and share that information with everybody, notwithstanding their copyright of the publication that they have. But we would welcome input on which aspects of intellectual property, the protection, the licensing, the new ways to exploit it are the best ways to grow the economy. But that's only half of the equation. The other half is, if you own something that you've created, our government should help you protect your right to it, just like we're going to help you protect your right to make sure that your car isn't stolen off the street.
Thank you. I know he's got to go, and no burning question. Your staff has been very diligent at pulling my arm here.
Thank you. We look forward to continuing to work with all of you. Our door is always open, and we welcome your ideas about how to make sure that people do have the ability to protect their privacy on the internet. Thank you. Thank you.